second reading.
Mr. Speaker, sir, I move that the Constitution Amendment Bill number 5 of 2024 and the Political Financing Bill number 6 of 2024 be read together a second time as they relate to the same subject matter. Mr. Speaker, sir, it is with a deep sense of satisfaction that I'm presenting today these two historic bills, through which the government is fulfilling yet another of its major commitments, which it took vis-à-vis the nation in 2019. These two bills aim at introducing the much-needed and long-awaited transparency and accountability in political financing in our country. The presentation of these two bills today is also another unequivocal testimony of the government's willingness and commitment to safeguard and enhance public confidence in our democratic system and consolidate the health of our democracy. Mr. Speaker, sir, the House will recall that during our first mandate, we had made a pledge to the nation to regulate political financing. That pledge was duly reflected in the government program 2015-2019. And in fulfillment of that commitment, we did come up in 2019, after much efforts and wild consultations, with two bills, namely the Constitutional Amendment Bill number 13 of 2019 and the Political Financing Bill. The aim of those bills was precisely to plug the transparency and accountability gap in political financing in our country. It was, in fact, the first concrete attempt in our political history to regulate political financing in our country, although the issue had been on the political agenda for nearly 2 decades. However, as the House is also aware, the bills were regrettably not supported by the then opposition, much to the disappointment of the people of this country, who had been impatiently awaiting appropriate political financing legislation to enhance public confidence in our political system. Instead of supporting the laudable initiative of the government to promote a culture of transparency and integrity in the political arena, the then opposition chose to play petty politics and came up with all sorts of lame excuses to justify their untenable stand on those bills. In fact, they did not have single valid argument not to vote for the bills. Most of their interventions were only empty rhetoric. Mr. Speaker, sir, had those bills been voted at that time, we would have by now gone a long way in addressing the lingering suspicion and public concerns about unregulated political finance in our country, which I must say was reinforced in the aftermath of the infamous coffers saga. Mr. Speaker, sir, the need to regulate political financing is long overdue. And as far as we, on this side of the House, are concerned, we reckon that the absence of an appropriate regulatory regime for political financing remains an important gap in our anti-corruption framework. This is the reason why, in our electoral manifesto of 2019, we maintained our pledge to introduce a new bill on the financing of political parties, and that pledge was faithfully reflected in the government program 2020-2024. In order to fulfill that commitment, the government set up a ministerial committee in November 2022 under my chair, with a view to making recommendations on, inter alia, the regulation of the financing of political parties. The committee examined the different aspects and issues surrounding political finance regulations, including its essential building blocks and core principles, namely the oversight and enforcement mechanism, prohibited donations, spending limits, accounting and record keeping, reporting and disclosure, registration of political parties and sanctions, amongst others. The committee also examined the views expressed and counter-proposals made by members of the National Assembly during the debates on the Political Financing Bill in 2019, including those from the opposition side. A first draft of the Political Financing Bill and the Constitution Amendment Bill was prepared by the Attorney General's Office based on the recommendations of the Ministerial Committee. After further discussions and fine-tuning, the draft bills were widely circulated on 29th April 2024 for consultation purposes. In fact, copies of the bills were sent to each and every member of the National Assembly, the Electoral Supervisory Commission, the Electoral Commissioner, the Financial Services Commission, Business Mauritius, and the International Institute for Democracy and Electoral Assistance, International IDEA. A copy each of the two bills was also posted on the website of the Prime Minister's Office, and members of the public were also invited to submit their views, comments, and/or counter-proposals. Mr. Speaker, sir, following the consultation exercise, my office received comments and counter-proposals from the following institutions and persons: the Electoral Supervisory Commission, the Electoral Commissioner, the Financial Crimes Commission, Business Mauritius, Transparency Mauritius, International IDEA, and two parliamentary private secretaries, namely Honourable François and Honourable Nakchedi. Mr. Speaker, sir, all the observations made and counter-proposals received following the consultation exercise have been duly considered by the Ministerial Committee. And the draft Political Financing Bill has been reviewed to accommodate certain observations and counter-proposals made. I must say that the proposals contained in the two bills have been welcomed by the Electoral Supervisory Commission, the Electoral Commissioner, the International IDEA, and Transparency Mauritius. In fact, the Electoral Supervisory Commission considers that the Political Financing Bill is in the national interest, ensures fairness, and aims at reducing improper influence and corruption by making provision for accountability and transparency with regard to the electoral process. The Electoral Commissioner, on his part, sees the proposals for regulating political financing embodied in the bill as being robust, well-structured, and comprehensive, and containing clearly defined provisions aimed at promoting transparency, accountability, and integrity in political financing. International IDEA, on its part, considers that overall, the draft bill quite sufficiently covers a wide range of political finance issues and is mostly in line with global regulatory trends. It has also drawn attention to some emerging issues that may be worth considering in the future. Transparency Mauritius has, on its part, expressed its gratitude for the government's efforts and commended the initiatives taken, and it also made certain suggestions. Mr. Speaker, sir, before delving into the content of the two bills, I would like to briefly explain the stand of the government on the issue of public funding of political parties. This issue was carefully examined by the Ministerial Committee, which took note of, inter alia, the recommendations made in previous reports on this particular issue, namely the report of the Sachs Commission of 2001 and the Yangxing report of 2004, and also international practice in this regard. Admittedly, public funding of political parties is a common feature in many foreign jurisdictions. However, its forms and objectives vary considerably from one country to another. The main argument in favor of public funding is that it can contribute to ensure, to a certain extent, a level playing field in a political contest. However, it remains questionable whether public funding can actually help create a level playing field among political parties. It is arguable that, on the contrary, public funding could well accentuate the disparity between major parties and emerging ones, given that a threshold would inevitably have to be imposed for a party to qualify for public funding. Even with fair eligibility and allocation criteria, we may end up with a polarization of the political arena, given that only major political parties would ultimately benefit from public funding, and smaller parties would run the risk of being driven out. It can also be argued that public funding may lead to an over-reliance of political parties on such funding and gradually disconnect the party from its grassroots. The Ministerial Committee felt that, although public funding may have certain advantages, public opinion in Mauritius is still, in general, not in favor of the idea of financing political parties from taxpayers' money. The Ministerial Committee also considers that the objectives of the Political Financing Bill, as enunciated in its explanatory memorandum, can be achieved without necessarily introducing the element of public funding. Mr. Speaker, sir, I must underline the fact that through these bills, we are also fulfilling one of our important international and regional obligations in relation to political financing, namely, under the United Nations Convention Against Corruption, UNCAC, and the African Union Convention on Preventing and Combating Corruption. As a matter of fact, the UNCAC, which Mauritius signed in 2003 and ratified in 2004, provides as follows in Article 7.3 of the Convention, and I quote, each state party, shall also consider taking appropriate legislative and administrative measures consistent with the objectives of this convention and in accordance with the fundamental principles of its domestic law to enhance transparency in the funding of candidatures for elected public office and, where applicable, the funding of political parties, unquote. Moreover, Article 10 of the African Union Convention on Preventing and Combating Corruption which Mauritius signed in 2003, but ratified only in 2018, and joins state parties to inter alia, and I quote, adopt legislative and other measures to A. Proscribe the use of funds acquired through illegal and corrupt practices to finance political parties, and B. Incorporate the principle of transparency into funding of political parties, unquote. Mr. Speaker, sir, the framework for the regulation of political finance, which we are proposing in the new political financing bill, is very much in line with the philosophy enunciated in Articles 7 and 10 of the UNCAC and the AU Convention, respectively. It should also be highlighted that neither of these conventions imposes any obligation on state parties to introduce public funding of political parties or candidates. Mr. Speaker, sir, the preparation of these two bills has been a complex task involving evaluation of different options and prioritizing competing objectives. Although we have drawn inspirations from best practices in foreign jurisdictions, the proposed framework for regulating political finance is largely homegrown and is crafted in a manner that takes into account the specificity of our electoral system and our social and political context and realities. We have also taken particular care not to impose unnecessary burden on political parties, candidates, campaigners, and citizens, whilst ensuring that the legislative objectives are met. We have therefore opted for a political finance regulation framework that is simple, effective, and enforceable. Mr. Speaker, sir, let me now highlight the salient features of the two bills. I shall first take the Constitution Amendment Bill, which seeks to amend the Constitution in order to extend the powers and functions of the Electoral Supervisory Commission and the Electoral Commissioner to cover matters relating to political funding. Section 41(1) of the Constitution presently empowers the Electoral Supervisory Commission to have general responsibility for and to supervise the registration of electors for the election of members of the National Assembly. The powers and functions of the Electoral Commissioner are, pursuant to Section 41(2) of the Constitution, also presently limited to registration of electors and conduct of elections. Clause 2 of the Constitution Amendment Bill is accordingly amending subsections 1, 2, and 3 of Section 41 of the Constitution with a view to vesting additional powers and functions upon the Electoral Supervisory Commission and the Electoral Commissioner in matters relating to political financing. Mr. Speaker, sir, I now come to the Political Financing Bill. As mentioned in the explanatory memorandum, the object of this bill is to provide for accountability and transparency in political financing with a view to promoting a level playing field, ensuring fair competition, and preventing improper influence and corruption. Clause 2 of the bill provides, inter alia, for a clear definition of the terms political donation, monetary donation, and donation in kind, as follows. Political donation means a monetary donation and a donation in kind. Monetary donation means donation in cash and with respect to a registered political party. includes any money lent to that party which has been written off by the lender, but does not include a membership fee paid to that party. Donation in kind means any of the following sponsorship or services provided to a recipient: publicity in the media and on billboards, elections, paraphernalia, including banners, flags, buntings or posters, campaign promotion shirts, t-shirts, polo shirts and caps, advertising materials such as sample ballot papers, pamphlets or stationery, transport facilities, public address system, equipment, goods or facilities including marquees and halls, but does not include sponsorship or services excluding those referred to in paragraph A, rendered personally by a volunteer, or free airtime for political broadcast. Mr. Speaker, sir, we have opted for a definition of donation in kind that is wide enough to capture most of the costly items which a party may receive as donation in kind, especially during an election period, and which should be accounted for. I wish to point out that the proposed definition of donation in kind now includes items such as transport, marquees, and public address system, as these constitute high-cost components in an election campaign. However, for the sake of enforceability, petty items and services provided by volunteers and free airtime for political broadcast have been excluded from the definition. Moreover, monetary donation will include any loan granted to a party which has been written off by the lender. Clause 3 of the bill provides that the Act will apply to any political party, a member of the National Assembly, a candidate, an election agent that receives political donations. Part 2 of the bill, which includes clauses 4 to 10, lays down the rules on political donations and covers, inter alia, issues such as who can accept political donations, what are the permissible sources of political donations, and the rules governing such donations by private entities. Mr. Speaker, sir, the House will recall that the Political Financing Bill of 2019 required all political donations to be channeled through the Treasurer. It was argued that that requirement would lead to bottlenecks and impose undue burden on the Treasurer. This issue has been addressed in Clause 4 of the present bill, which accordingly provides that a political party registered with the Electoral Supervisory Commission, a member of the National Assembly, and a candidate and his election agent can accept a political donation. Clause 5 of the bill imposes an obligation on any person receiving a cash donation on behalf of a political party to remit such donation to the party leader or the treasurer of the party within 7 days of receipt, with all necessary information for proper recording and reporting. Similarly, information on any donation in kind received by a person on behalf of a party should be communicated to the party leader or treasurer of the party within 7 days of receipt for recording and reporting. Clause 6 of the bill pertains to political donations received on behalf of a candidate by his election agent. This clause imposes an obligation on the election agent receiving cash donations on behalf of the candidate to remit same to the candidate within 7 days with all required information for proper recording and reporting. There is a similar obligation on the election agent to communicate to the candidate information pertaining to donation in kind received by him on behalf of the candidate. Clause 7 of the bill lays down the rules governing political donations by private entities. Clause 7 provides that a private entity cannot make a political donation until and unless there is a written resolution of its governing body authorizing it to do so. Such political donations should be disclosed in its financial statements, indicating the amount of cash donations and monetary value of donation in kind made, and a political donation by a private entity must be made only by checks or electronic means. I should point out that the definition of private entity now includes an association, a foundation, a limited liability partnership, a trust, or such other private entity as may be prescribed. Mr. Speaker, sir, Clause 8 of the bill imposes a duty on the leader or treasurer of a political party to deposit any unutilized cash donations received on behalf of the party into the bank account of the party. Moreover, any unreturned party candidate must, after the election, remit any unutilized cash donation to the leader or to the treasurer of his party. A member of the National Assembly will be required to deposit any unutilized cash donation in a separate bank account to be opened by him, and no other money should be deposited into that same account. Clause 8 further provides that in case a party member passes away, any available balance of donation deposited into the bank account shall be deemed to belong to his party. Mr. Speaker, sir, Clause 9 of the bill prescribes the acceptance of political donations from the following sources: an anonymous person, a state-owned enterprise, a statutory corporation, a religious body, a non-governmental organization which is in receipt of subsidy or grant from the government, a CSR fund set up under Section 50L of the Income Tax Act, a non-resident citizen, a non-citizen, a foreign government or foreign entity, or such other bodies as may be prescribed. Mr. Speaker, sir, these prohibited sources of political donations are generally in line with international practice. In regard to donations from foreign sources, I would like to point out that according to the database of the International IDEA, out of 180 countries, 126 have placed some form of ban on donations from foreign governments or foreign individuals. Such countries include the United Kingdom, the United States of America, Japan, Norway, Canada, Brazil, and France. I would like to highlight the fact that the 2019 Political Financing Bill did not include non-resident citizens as a prohibited source of political donation. However, this time, the Ministerial Committee considered that allowing non-resident citizens to make political donations would constitute a loophole in the legislation, as it could be used to circumvent the law and allow the channeling of donations from other prohibited sources. It is also to be noted that a non-resident citizen has been defined in the bill as being a citizen whose permanent residence is outside Mauritius and who is not registered as an elector for the purpose of a general election. Mr. Speaker, sir, Clause 10 of the bill prohibits a recipient from accepting a donation which he suspects to originate from the proceeds of a crime and imposes a duty on him to report such cases to the Financial Crimes Commission. A similar duty has been imposed on the Electoral Commissioner to report any suspicious transaction to the Financial Crimes Commission. Mr. Speaker, sir, Part 3 of the bill, which comprises clauses 11 to 16, provides for another important pillar of an effective political finance regulation, and that is the recording and accounting of political donations. In fact, Clause 11 of the bill requires all recipients of political donations to keep a register to be known as a register of political donations. The register shall contain the following information: the amount of monetary donations received, whether in cash, by check, or by electronic means, the nature and the monetary value of donations in kind received, the date the political donations were received, the names and addresses of the donors, and such other particulars as may be prescribed. Moreover, a member of the National Assembly, an unreturned candidate, and an election agent will be required to keep his respective register of donation for a period of 5 years. Clause 12 of the bill requires all unreturned party candidates to submit within 7 days of the proclamation of the election results a report to his treasurer or to his party leader. Such reports must contain the following information: the amount of monetary donations received, whether in cash, by check, or by electronic means, the amount of any unutilized monetary donation, the nature and monetary value of donations in kind received, the date on which the political donations were received, and the names and addresses of the donors, including their contact details. On the other hand, a returned candidate will be required to submit a similar report within 7 days after the elections, and thereafter he will have to submit such report to his leader or treasurer on a quarterly basis. This obligation on a candidate to submit reports on political donations to his party leader will give the latter a droit de regard and will act as an additional safeguard against any risk of illicit money polluting the political process. Clause 13 of the bill imposes a duty on the treasurer of the party to keep all accounting records of the party's transactions in terms of donations received and payments made, so as to enable him to prepare the statement of accounts required to be submitted under this law and to keep same for a period of at least 5 years. Mr. Speaker, sir, the House will recall that the 2019 Political Financing Bill required a political party whose gross income or total expenditure in any financial year exceeded 1 million rupees to get its accounts audited by a qualified auditor before submission to the Electoral Supervisory Commission. In order to reduce the burden on political parties, Clause 14 of the present bill enjoins the treasurer of every political party only to prepare and submit the party's audited statement of accounts to the Electoral Commissioner, not later than 60 days after the end of every financial year. There would be no need to have the accounts audited by a qualified auditor. However, Clause 14 also empowers the Electoral Commissioner to appoint a qualified auditor to audit any unaudited statement of accounts. Mr. Speaker, sir, I should also highlight the fact that all such statement of accounts submitted to the Electoral Commissioner shall be open for consultations by the public. It is of note that there will be no legal obligation on a member of the National Assembly to submit an annual statement of accounts. However, a party candidate and an independent candidate will be required to submit their usual election returns under the Representation of the People Act. A similar obligation to submit election returns is being imposed on a political party through a consequential amendment to the Representation of the People Act, which is being brought by Clause 28D of the bill. Clause 16 of the bill requires the Electoral Commissioner to prepare and submit a report based on the statement of accounts of all registered parties to the National Assembly not later than 120 days after the end of every financial year. In the 2019 bill, there was no mention of the information that such report should contain. The present bill provides that this report to the National Assembly should contain the following information: any amount received by each party in respect of subscription and membership fees from its members, interests, monetary donations, and any other activity. The monetary value of donations in kind received, any expenditure incurred and the reason for such expenditure, any asset, including any amount of cash in hand and cash at bank, together with the name of the bank where the money is deposited, and any liability. It goes without saying that any donations in kind received should be valued at its market rate. Mr. Speaker, sir, Part 4 of the bill lays down the role and powers of the Electoral Supervisory Commission and the Electoral Commissioner with regard to supervision and monitoring of political financing. The Electoral Supervisory Commission and the Office of the Electoral Commissioner have been chosen as the oversight body for the monitoring of political financing, as they are two independent constitutional bodies of high repute, both regionally and internationally, and are best suited for such role. Besides, globally as well, the most common approach is to entrust the oversight role for political financing to election management bodies. Clause 17 of the bill accordingly vests the Electoral Supervisory Commission with general responsibility for the supervision of all matters relating to political financing. Clauses 18 to 20 of the bill vest the Electoral Commissioner with powers of investigation as well as wide powers of entry and search in order to enable him to discharge his new functions in an effective manner under the supervision of the Electoral Supervisory Commission. Clause 19 of the bill empowers the Electoral Commissioner to order any person to appear before him and to produce any book, document, record, or information which he may require in the course of his investigation. He may also order a person to furnish a statement in writing under oath. Failure to comply with an order issued by the Electoral Commissioner shall constitute an offence under this Act. Clause 20 of the bill provides that a magistrate may, on sworn information, issue a warrant to an officer designated by the Electoral Commissioner authorizing him to enter and search any premises at all reasonable times where there is reasonable ground to believe that there is, on such premises, evidence which may assist the Electoral Commissioner in an investigation. However, such searches should be carried out in presence of the owner of the premises or his duly authorized agent, who should, prior to the search, be provided with a copy of the warrant. Clause 25 of the bill further provides that any information obtained by the Electoral Commissioner in the course of his investigation from any book, document, record, and so on, shall be admissible in court. Mr. Speaker, sir, it is also noteworthy that the Electoral Commissioner is being empowered under Clause 21 of the bill to issue directives to a person to take remedial actions for having breached any provision of the Act, or to take measures to prevent any contravention of the Act within a specified time period. Where such a directive is issued to a political party, it will be incumbent upon the treasurer of that party or the leader of that party or any other person concerned with the management of the party to comply with such directives. I should point out that non-compliance with such directives shall constitute a separate offense for each day of non-compliance, punishable by a fine of 5,000 rupees per day up to a maximum of 5 million rupees. Provision has nevertheless been made under Clause 21(3) of the bill for a person to whom such a directive has been issued to have the opportunity to make representations to the Electoral Commissioner within such time frame as may be prescribed. Mr. Speaker, sir, Part 5 of the bill deals with the procedures and requirements for the registration of political parties for the purpose of accepting political donations. Clause 22 of the bill enjoins any political party wishing to accept political donations to be registered with the Electoral Supervisory Commission. An application for such registration may be made at any time to the Commission, and the applicant should provide the following information to the Commission: the names, address, and symbol of identification of the political party, the names, signature, and residential address of the leader, president, secretary, treasurer, and other office bearers of the political party, whether the political party is represented by any member in the National Assembly, evidence that the political party holds a bank account, and such other information or document as the Commission may determine. A political party that does not hold a bank account at the time of application may be registered by the Commission, provided that the party shall, within 1 month of its registration, open a bank account, failing which its registration will lapse. Clause 22(3) of the bill further provides that no application for registration will be entertained by the Commission during the period starting 5 days after the day on which writs for a general election have been issued and ending on the day the election results are proclaimed. Moreover, where the Commission decides to register a party, it shall give notice of such registration in the Government Gazette. Where the Commission decides to reject an application, it will have to give the reasons therefor. Mr. Speaker, sir, during the debate on the 2019 Political Financing Bill, few members had suggested that the bill should have provided for a right of appeal in case the ESC decided to reject an application for registration. Clause 22(7) of the present bill accordingly provides that any party aggrieved by the decision of the Commission not to register it, may appeal to the Supreme Court, and such appeal shall be determined by a judge within 14 days. In case the Commission decides to reject an application made not later than 5 days after the day on which writs for general elections have been issued, an appeal against the decision should be made within 24 hours of the decision, and the appeal should be heard and determined not later than 2 days before the nomination day. Moreover, the determination of the judge shall not be subject to appeal. Mr. Speaker, sir, proportionate and dissuasive sanction is an essential element in ensuring the effectiveness of any political financing legislation. Honourable members will have noted that in different clauses of the bill, provisions have been made for sanctions in the form of financial penalties only. A general provision is made in clause 25 of the bill to the effect that any person who otherwise contravenes the Act shall commit an offence and on conviction be liable to a fine not exceeding 5 million rupees. The proposed fine up to 5 million rupees, coupled with the power vested in the Electoral Commissioner to issue enforceable directives, which I mentioned earlier, is considered to be dissuasive enough to ensure compliance with the law. Government has opted for financial penalties instead of other forms of sanctions like imprisonment, disqualification, or loss of office, deregistrations, amongst others, as we consider that a fine is simple and relatively easy to enforce and is more in line with our democratic tradition. It is also the most common form of sanction internationally. Mr. Speaker, sir, clause 26 of the bill grants jurisdiction to a magistrate to try any offence under this Act and to impose any penalty provided therefor. Clause 27 of the bill empowers the President of the Republic to make regulations for the purposes of the Act, after consultation with the Electoral Supervisory Commission and the Electoral Commissioner. It is to be noted that this is similar to the provisions of Section 85 of the Representation of the People Act, which also empowers the President to make regulations for the purposes of the Act. Clause 28 of the bill deals with the consequential amendments to the Representation of the People Act. Section 51 of the RPA is being amended to provide for an upward review of the ceilings of election expenses so as to bring it to a more realistic level. As the House is aware, the present ceilings were set in 1989 and have not been revised since then. The House will recall that the Sachs Commission identified the violation of the unrealistic expenditure ceilings as being a big loophole in our law, which makes a mockery of the whole issue of placing ceiling on expenses. The Commission therefore forcefully recommended an increase of the expenditure ceilings to a reasonable and realistic level so as to match the costs of elections. Accordingly, the expenditure ceilings are being revised through this bill as follows. For a National Assembly election, in respect of a party, a ceiling of 1.5 million rupees per constituency is being prescribed, provided that the party has fielded at least one candidate in that constituency. It is to be noted that so far, there was no ceiling prescribed on the expenditure of political parties. In respect of a candidate who is not the only candidate belonging to a party at the election in the constituency. The ceiling is being increased from 150,000 rupees to 1.5 million rupees. In respect of a candidate who is the only candidate belonging to a party at the election in the constituency, the ceiling will be 2 million rupees. And in respect of a candidate who does not belong to any party at an election in a constituency, the ceiling will be 2 million rupees. For the municipal city council or municipal town council election, the ceiling is being increased from 50,000 rupees to 300,000 rupees per candidate. For village council elections, the ceiling is being increased from 50,000 rupees to 200,000 rupees per candidate. For a local region election or an island region election in Rodrigues, the ceiling is being increased from 100,000 rupees to 300,000 rupees. I wish to point out that these expenditure ceilings include the monetary value of the donations in kind that a party or a candidate may receive. Mr. Speaker, sir, the other amendments proposed in the Representation of the People Act are as follows. 1. The limit of expenses to be incurred by a candidate, as provided in Section 53 of the Representation of People Act, is being increased as follows. Expenditure for the candidate's personal living expenses is being increased from 25,000 rupees to 150,000 rupees. Petty expenditure is being increased from 2,500 rupees to 25,000 rupees. 2. In Section 56, the minimum expenditure to be supported by vouchers is being increased from 30 rupees to 5,000 rupees. 3. A new Section 56A is being introduced to impose an obligation on the treasurer of every political party which has fielded at least one candidate at a general election to make an election return to the Electoral Commissioner within 90 days of the proclamation of the results. As the House is aware, at present only candidates are required to submit such election returns, given that expenditure limits are applicable only to candidates. I wish to point out that such election return in case of a party alliance should be made jointly by the respective treasurer of the political parties constituting the alliance. Insofar as candidates are concerned, they are required to submit their election returns within 6 weeks of the proclamation of results, as provided in the Representation of the People Act. 4. The fines prescribed in Part 5 for various election offences like illegal payment, hiring, bribery and treating, undue influence, and offences in respect of ballot boxes are being increased from 1,000 or 2,000 rupees to 50,000 rupees. 5. A new Section 72B is being inserted to provide for temporary political headquarters and campaign quarters, commonly known as BAS. There shall be not more than one political headquarters per constituency, municipal city council, municipal town council, district council, or local region, as the case may be, and not more than one temporary political campaign quarter, that is the BAS per polling station. Moreover, no political headquarters or BAS shall be set up before the issue of writs of election. 6. A new Section 72C is being inserted to empower the Electoral Supervisory Commission to issue directives to ensure compliance with the provisions regarding temporary political headquarters and campaign headquarters. A person on whom a directive will be served will have the possibility of making representations to the Electoral Supervisory Commission as he deems necessary. The functions and powers of the Commission under this new section shall be discharged and exercised by the Electoral Commissioner. And 7, Section 74(1) presently provides, inter alia, that a person who is found guilty of an illegal practice shall be liable to a fine not exceeding 1,000 rupees. This fine of 1,000 rupees is also being increased to 50,000 rupees. Mr. Speaker, sir, while framing the proposals embodied in the Political Financing Bill, we have drawn inspirations from best practices in both established and transitional democracies, taking into account our own local context and realities. The House may be aware that in recent years, a significant number of countries have introduced legislation to reduce the negative impact of money in politics. As far as Mauritius is concerned, we do not have, as yet, any specific legislation on political financing, despite our international commitment vis-à-vis the UNCAC more than 20 years ago. The absence of such a legislation indeed constitutes a big gap in our governance and democratic framework. As I have said previously in this House, there is no universally agreed system of regulating political finance. Each country has to craft its own model that suits its local context. We consider that the proposals embodied in these two bills are appropriate and workable in our local context. Mr. Speaker, sir, I would invite the opposition this time to look at the proposals in a dispassionate and rational manner and to put national interest above party political considerations. As I stated earlier, in 2019, the opposition chose to be on the wrong side of history when they decided to thwart the government's initiative and frustrate the will of the people by not supporting the political finance bill. Today, they are being given an opportunity to make amends and redeem themselves. The House and the population will recall that for the 2014 general election, the Labour Party MMM coalition promised in their electoral manifesto to introduce legislation to regulate political financing, although that was not sufficient enough to convince the electorate. For the 2019 general election, the MMM, in its electoral manifesto, promised to, and I quote, introduire un financing of political parties bill efficace pour permettre aux partis politiques d'assumer démocratiquement leur rôle sans les ficelles des financements occultes, unquote. In regard to the Labour Party, surprisingly, or should I say unsurprisingly, we do not see any such commitment in their 2019 electoral manifesto. But be that as it may, such pledges to promote integrity and clamp down on corruption must be more than campaign promises and words on paper. Therefore, I make an appeal to the opposition, who often present themselves as anti-corruption and integrity champions, to come forward and fulfill their commitment, not only towards the people of this country, but also towards the international community. Parliamentarians should be the first to take a moral stand and support a culture of integrity. It all begins with setting the right example. By helping to tackle corruption, parliamentarians can show they mean business. Mr. Speaker, sir, as I said earlier, the proposed bills constitute a much-needed legislative framework with the very lofty objective of strengthening our democracy. The people of this country are watching. The opposition will be well advised not to miss the opportunity this time, else the people will not forgive them. The government has done its part. It is time for the opposition to walk the talk and demonstrate what they stand for. This may not be a perfect bill. After all, there is no such thing as a perfect political financing legislation. But we need to start somewhere, and we can build on that in the light of experience that we gather as we go along. Mr. Speaker, sir, the 10th session of the Conference of State Parties to the UNCAC was held in December last in Atlanta, USA. One of the key issues which was on the agenda was precisely the question of how to stop opaque money from corrupting democracy. In that context, a broad coalition of more than 100 international institutions and civil society, including the International IDEA, the US-based International Foundation for Electoral Systems, and the UK-based Westminster Foundation for Democracy, made a joint appeal to the delegates attending the UNCAC Conference of Parties to further prioritize and enhance political finance transparency by, inter alia, closing loopholes for illicit funds in politics, improving oversight and accountability, and strengthening international cooperation. Mr. Speaker, sir, to conclude my speech, I would like to quote the following from their submissions, which underscore the need for countries like Mauritius to regulate the role of money in politics, and I quote, "Political finance is a pivotal issue in the fight against corruption. The integrity of democratic processes is contingent on financial transparency and accountability in politics. The lack of transparency in political finance leads to waste or misuse of often limited public resources, posing a threat to the entire sustainable development agenda. When financial contributions to political parties, electoral campaigns, or candidates are opaque and unaccountable, this enables clientelism, fuels corruption, increases the cost of political participation, and destroys trusts in governments. These outcomes adversely affect public services, drive conflict, and make politics an exclusive club. These negative impacts are felt most keenly by women, young people, people with disabilities, and other marginalized groups," unquote. Mr. Speaker, sir, with this pertinent and insightful quote, I commend the bill to the House.
Recommended